Okay, as promised, we'll go on to the CPRA, the canons of the CPRA. Well, take note muna na you have to memorize the new lawyer's oath. Andun yan sa dulo ng SIPRA. You have to memorize it, okay? But now we're going to discuss independence and propriety. The canons of independence and propriety. Okay, let's begin. Okay. Again, para to sa mga members ng community and, well, if I have students here in basic legal and judicial ethics, sana makatulong. Okay, let's go. For the canon of independence, what is the concept of independence in the legal profession? Well, based on Canon 1, independence is what? The independence of a lawyer in the discharge of professional duties without any improper influence, restriction, pressure, or interference, direct or indirect, ensures effective legal representation and is ultimately imperative for the rule of law. Okay, what does that mean? The canon refers to what? Effective legal representation and what? Impartiality and neutrality of lawyers. Because what? They play a crucial role in upholding the rule of law. And for lawyers to be able to advocate zealously for the client's interests, and they should have no fear of any external influences. Next, what is the duty of a lawyer regarding accessibility of legal services? As a rule, a lawyer shall make legal services accessible in an efficient and effective manner. Section 1 of Canon 1 refers to access to justice. One of the fundamental principles of any legal system is ensuring that access to justice for all individuals is ensured. This means that legal services should be available and accessible to everyone, regardless of their financial status or social background. It is this provision, well, yeah, this is based on Canon 1, Section 1. This provision emphasizes that lawyers have a duty to make legal services accessible in an efficient and effective manner. What principles should a lawyer rely on when advocating a cause? Okay, a lawyer shall rely solely on the merits of the cause and not exert or give the appearance of any influence on nor undermine the authority of the court, tribunal, or other government agency or its proceedings. This is based on Section 2, Canon 1, refers to the merit-based practice of lawyers. A lawyer shall rely solely on the merits of a cause and not exert or give the appearance of any influence on nor undermine the authority of the court, tribunal, or other government agency or its proceedings. Let's look at this hypothetical problem. Sarah is a lawyer representing her client in a high-profile criminal case. During the trial, she becomes increasingly frustrated with the judge's rulings, which she believes are unfair and biased against her client. In a fit of anger, she loudly voices her displeasure in the courtroom, questioning the judge's competency and integrity. Now, what does this entail? Looking at this hypothetical, It shows that this outburst creates a tense and confrontational atmosphere in the courtroom, undermining the authority of the judge and the proceedings, which runs contrary to Section 2 of the merit-based practice. Sarah's action have not only violated the principle stated in Section 2 or the merit-based practice principle, but have also disrupted the proceedings and eroded the public's confidence in the legal system's fairness and impartiality. Okay, based on this one, what's the key points here? Again, it highlights the impartiality and fairness of the as a fundamental principle of the legal system. It is essential that judges, tribunals, and government agencies make decisions based solely on the merits of the case without any undue influence or interference. Okay? Seeks to preserve what? Judicial independence. And it seeks to, it realizes the importance of perception in the legal profession. It's not only about acting ethically but also maintaining the appearance of unethical conduct by prohibiting lawyers from giving the appearance of influencing or undermining the authority of the court. This provision helps maintain public confidence in the legal system. Even the perception of impropriety can erode the trust in the legal system. Okay. What considerations should not influence a lawyer when advocating a client's cause? A lawyer shall not, in advocating a client's cause, be influenced by dishonest or immoral considerations, external influences, or pressure. This is based on Section 3, Canon 1 of the CIPRA. Okay, let's look at this one again. Sarah is a lawyer representing a client, John, who is facing charges of embezzlement. Sarah is aware that John is guilty and has evidence proving his guilt. However, John is also a close friend of Sarah's and has been pressuring her to use her legal skills to help him evade conviction. John argues that their friendship should influence Sarah's approach to the case, even if it means resorting to dishonest or immoral tactics to secure his acquittal. What advice should you give Sarah? Well, Sarah should refer to Section 3 of Canon 1 of the CIPRA, freedom from improper consideration and external influences. Says that a lawyer shall not, in advocating a client's cause, be influenced by dishonest or immoral consideration, external influences, or pressure. The rationale behind this is that it is to maintain the integrity of, again, the legal system, protect the client's interests, and uphold public trust, and promote ethical conduct among lawyers. It is one of the key principles in legal practice that a lawyer should act with honesty, integrity, loyalty, and truthfulness to their clients while adhering to the highest standards of professionalism and ethical behavior. Under what circumstances can a lawyer assist a branch, agency, office, or officer of the government in interfering with a legal matter? Okay. Unless authorized by law or court, a lawyer shall not assist or cause a branch, agency, office, or officer of the government to interfere in any matter before any court, tribunal, or other government agency. This is highlighted in Section 4 of Canon 1. The general rule is, a lawyer shall not assist or cause a branch, agency, office, or officer of the government to interfere in any matter before the court, tribunal, or other government agency. What is the exception? There, unless authorized by law or court. What is a lawyer's duty regarding the client's decision on settling or compromising a case? Okay, a lawyer shall not allow the client to dictate or determine the procedure in handling the case. Nevertheless, a lawyer shall respect the client's decision to settle or compromise the case after explaining its consequences to the client. Based on Section 5 of Canon 1, there is a lawyer's duty and discretion in procedure and strategy. A lawyer, as stated here, shall not allow the client to dictate or determine the procedure in handling the case. What does this mean? This part of the provision emphasizes the lawyer's role as a legal professional who is expected to provide expert guidance and make informed decisions about the legal strategy and procedures to be followed in the case. It is based on the idea that lawyers have the training and expertise to understand the legal system, assess the strengths and weaknesses of a case, and determine the most appropriate legal strategy to achieve the client's objectives. Allowing a client to dictate or determine the legal procedure can be problematic because it may compromise the effectiveness of the legal representation, undermine the lawyer's professional judgment, or even lead to unethical or unlawful actions. Now, on the second paragraph, it recognizes that ultimately the client has the right to make important decisions in the case, particularly when it comes to settlement or compromise. However, it also emphasizes the lawyer's responsibility to fully inform the client about the potential consequences of such decisions. This includes explaining the legal implications, the risks, benefits, and other relevant factors associated with settling or compromising the case. The lawyer's role here is to provide the client with the information they need to make an informed and voluntary decision. Next question, we're on Canon 2. What is the canon of propriety? It says here that a lawyer shall act with propriety and maintain the appearance of propriety in personal and professional dealings. Bakit? Because as stated in Canon 2, propriety, a lawyer should, aside from this one, a lawyer should uphold the dignity of the legal profession consistent with the highest standards of ethical behavior. What conduct should a lawyer avoid? Okay, avoid. What are the conducts that lawyers should avoid? Based on Section 1 of Canon 2, a lawyer shall not engage in unlawful, dishonest, immoral, or deceitful conduct. You did. Again, you did unlawful, dishonest, immoral, or deceitful conduct. Now, what is the rationale of this one? Again, it's to uphold the integrity of the legal profession and to protect the public. Lawyers have special responsibility to uphold the law and conduct themselves ethically. When lawyers engage in unlawful, dishonest, immoral, or deceitful conduct, they undermine the public trust in the legal profession and make it more difficult for people to access to justice. Okay. This is highlighted in the case of it's the case Panagsan. Is it Panagsan? Panagsagan. Panagsagan versus Panagsagan. I think this is the case about the lawyer who had a extramarital affair. Okay, let's move on. How should a lawyer behave towards fellow members of the bar? Okay. A lawyer shall act with courtesy, civility, fairness, and candor towards fellow members of the bar. This is based on Section 2, referring to the dignified conduct or the standard of conduct expected among lawyers. Okay, based on Section 2, Canon 2, a lawyer shall respect the law, the courts, tribunals, and other government agencies, their officials, employees, and processes, and act with courtesy, civility, fairness, and candor towards fellow members of the bar. Second paragraph. A lawyer shall not engage in conduct that adversely reflect on one's fitness to practice law, nor behave in a scandalous manner, whether in public or private life, to the discredit of the legal profession. Let's look at this hypothetical. John, a lawyer with a successful practice, has recently been engaging in a series of increasingly confrontational and unprofessional behavior both inside and outside of the courtroom. He has also been he has been known to openly disrespect judges during hearings, argue aggressively with opposing counsel, and publicly berate his clients on social media when cases don't go his way. Additionally, he has been involved in several public altercations that have garnered negative media attention, and he regularly uses profanity and offensive language when communicating with his fellow attorneys. What rule of ethics did he violate? So again, he violated Section 2 of Canon 2 of the CPRA. On the first paragraph of Section 2 says that lawyers are entrusted with a great deal of power and responsibility. They have the ability to represent their clients in court, negotiate on their behalf, and advise them on their legal rights. Now, in order to maintain the public trust in the legal system, it is essential that lawyers conduct themselves in a respectful and professional manner. Now, on the second paragraph, it states that lawyers are expected to uphold the highest standards of ethical conduct, both in their professional and private lives. This is because their behavior can have a direct impact on the public's perception of the legal profession. If a lawyer is caught engaging in unethical or scandalous behavior, it can damage public trust in the entire legal system. Now, the rationale behind these rules is to protect the public and to ensure that lawyers maintain the highest standard of professionalism. When lawyers uphold these standards, it helps to ensure that the legal system is fair and just for everyone. Okay. What is the prohibition regarding the behavior reflecting on one's fitness in practicing law? Again, that's still based on Section 2. A lawyer shall not engage in conduct that adversely reflect on one's fitness to practice law or behave in a scandalous manner. What forms of abuse or harassment should a lawyer avoid creating or promoting? Again, based on Section 2. A lawyer shall not create or promote an unsafe or hostile environment that shall not commit any form of physical, sexual, psychological, or economic abuse or violence against another person. Okay. This question is based on Section 3. the lawyer's duty to create a safe environment and avoid all forms of abuse or harassment. Section 3 of Section 3 of Canon 2. But the rationale behind this is what? Number 1, is to promote a safe and respectful environment. Number 2, it highlights the prohibition of abuse and violence. And last, it promotes it prevents gender-based harassment and discrimination. What language should a lawyer use in his personal and professional dealings? A lawyer shall only use dignified, gender-fair, and child and culturally sensitive language. Hi, this is based on the provisions of Section 4, Canon 2. Okay. This one, what language should a lawyer use? Should only use dignified, gender-fair, child and culturally sensitive language. Now on this one, what kind of lawyer should a lawyer avoid using? A lawyer shall avoid or shall not use language which is abusive, intemperate, offensive, or otherwise improper, whether oral or written, through traditional or electronic means. Refer to the case of Cañete versus Puti, wherein attorney Puti employed impertinent and discourteous language against opposing counsels. He used the term bakla in a derogatory way, which is no longer acceptable, as it should have been in the first place. What is required of a lawyer in terms of fairness and obedience? A lawyer must insist on the observance of fairness and obedience of the law. This is based on Section 5. It is the duty of a lawyer to observe fairness and obedience. Okay, based on this section, it highlights the legal profession's role in upholding justice, fairness, obedience to the law, and professional responsibility. These principles should be observed in both personal and professional engagements. What conduct is prohibited for lawyers towards others? Sino yung others? Lawyers are prohibited. Others, including lawyers, fellow lawyers, clients, witnesses, or court officials. They are prohibited from harassing or threatening fellow lawyers. Harassing or threatening fellow lawyers, clients, witnesses, or court officials. This is based on what? Section 6. A duty to avoid harassing or threatening conduct. How should a lawyer's demeanor be in court and government agency proceedings? A lawyer should observe formal decorum and maintain an appropriate appearance. In Section 7 of Canon 2, it refers to formal decorum and appearance of lawyers. The duty to observe formal decorum and appearance says here that a lawyer shall observe formal decorum before all courts, tribunals, and other government agencies. A lawyer's attire shall be consistent with the dignity of the court, tribunal, or other government agency, with due respect to the person's sexual orientation, gender, identity, and gender expression. You can see here Second paragraph highlights the court's respect for diversity. The mention of due respect to the person's sexual orientation, gender identity, and gender expression underscores the importance of inclusivity and non-discrimination. It acknowledges that individuals may have diverse backgrounds and identities, and lawyers should be sensitive to this diversity in their attire, ensuring that it's neither offensive nor discriminatory. Okay. Bakit na-highlight dito yung appropriate appearance? Well, in its simplest, to explain it simply or in the simplest sense, lawyers' credibility is unavoidably connected with his appearance. It is essential in court. Inappropriately casual or provocative attire could undermine a lawyer's professionalism and credibility in the eyes of judges and clients and opposing counsel. Now, dressing appropriately helps lawyers command respect and maintain their effectiveness in advocating for their clients. May case na yan na discuss natin sa class regarding a lawyer who prioritized aesthetics over proper decorum. Now, what is prohibited regarding providing misleading information to the court, tribunal, or other government agencies? It is prohibited for lawyers. Lawyers must not misquote, misrepresent, or mislead the court, and must not present someone else's ideas or words as their own. Okay, there are several layers here. This is based on Section 8 of Canon 2. Prohibition against misleading the court, tribunal, or other government agency. Okay, first layer, misquoting, misrepresenting, or misleading the court. Lawyers here have a duty to uphold the integrity of the legal system. Paulit-ulit na. Now, misquoting, misrepresenting, or misleading the court can undermine the pursuit of justice and erode trust in the legal system. Now, the rationale here is to ensure that lawyers present accurate and truthful information to the court to facilitate fair and just proceedings. Now, if lawyers are allowed to misrepresent the existence of content or contents of documents, it could lead to unjust outcomes and hinder the discovery of relevant evidence. Now, the rationale here is to maintain the credibility of the legal profession and its processes. It also says in Section 8 the importance of presenting, or the duty to avoid presenting someone else's ideas or words as their own. Now, plagiarism is unethical and unacceptable in any profession, including law. The legal profession places high value on originality and intellectual honesty. Lawyers must provide due credit to the sources or their legal arguments, citing relevant laws, statutes, and legal scholarship. What else? Okay. We've discussed this further in the case of Sitaka versus Palomares, in the case of the creation of fake bail bonds. Okay. How should a lawyer behave when presenting or confronting a witness? Lawyers should avoid impropriety, including coaching, abusing, discriminating against, or talking to a witness during a trial break. Okay. This is based on section 9, or obstructing access. Oh no. I think it's the second paragraph of section 8. Yep. No, it's not. Okay, let's go to the next question. What actions are forbidden for lawyers concerning evidence during trial? Now, this is section 8. Lawyers must not obstruct another lawyer's access to evidence or alter, destroy, or conceal evidence. Again, it is to preserve the integrity of the legal system and to ensure that a trial is fair, allowing the lawyers to obstruct access to evidence or tamper with it could compromise this principle. How should a lawyer behave when presenting or confronting a witness? Okay. This is based on section 10. Conduct in the presentation of a witness. A lawyer shall avoid all forms of impropriety when presenting or confronting a witness, including coaching, abusing, discriminating against, or talking to a witness during trial break. Back it. Lawyers should not coach witnesses, meaning they should not instruct or pressure witnesses to provide specific answers or testimony. The rationale behind this rule is to preserve the witness's impartiality and credibility. Now, witnesses should provide their testimony truthfully and without external influence to ensure that the court gets an accurate account of the events. Okay, what else? Avoid discrimination and harassment and abuse. Well, this is to protect the rights of the witnesses. When the rights of the witnesses are protected and ensured that it is protected, they're more likely to cooperate. Now, let's talk about the restrictions on communication during examination. Now, lawyers are not allowed to talk to witnesses during breaks or recesses in the trial while the witness is still under examination. Why? This is to prevent any attempt to influence the witness's testimony or undermine the credibility of their statements. It ensures that the examination process remains transparent and unbiased. Let's go to the duty. What is the duty of a lawyer regarding false representations or statements? Now, a lawyer shall not make false representation or statements. A lawyer shall be liable for any material damage caused by such false representation or statements. A second paragraph. When should a lawyer correct false or inaccurate statements or information? Now, a lawyer should correct false or inaccurate statements and informations made in relation to an application for admission to the bar, any pleading, or any other document required by or submitted to the court, tribunal, or agency as soon as its falsity or inaccuracy is discovered or made known to him or her. Okay, in this case, when is the proper time to correct the false or inaccurate statements? As soon as the discovery is made. Okay, now what is the rationale of this? This is based on section 7 of Canon 2, false representations or statements, and the lawyer's duty to correct. It states here that the lawyer shall be liable to any material damage caused by the false statements. What else? It highlights also the duty to correct false or inaccurate statements. Lawyers have a duty to correct false or inaccurate statements and information as soon as they become aware of the falsity or inaccuracy. This duty ensures that lawyers promptly rectify any mistakes or misrepresentations that they have inadvertently made. It promotes transparency and helps maintain the integrity of legal proceedings. What should a lawyer do if they have information about a transaction or unlawful activity? As a rule, a lawyer shall report to the appropriate authority any transaction or unlawful activity that is required to be reported under relevant laws, including the submission of covered and suspicious transaction under regulatory laws such as those concerning anti-money laundering. What should a lawyer do if they encounter dishonest, deceitful, or misleading conduct? A lawyer shall immediately inform a court, tribunal, or other government agency of any dishonest, deceitful, or misleading conduct related to a matter being handled by the said lawyer before such court, tribunal, or other government agency. This is based on Section 12 of Canon 2. Take note that in Section 12 says that a baseless report shall be subject to civil, criminal, or administrative actions. So, while there is a duty to report any dishonest, deceitful, or misleading conduct, any report that is found to be baseless or based on a whim shall be subject to civil, criminal, or administrative actions. Now, what is the rationale of this rule? First is to maintain the integrity of the legal system, again. Second is to prevent any unlawful activities, especially in terms of anti-money laundering regulations and other financial crimes. Preserve the attorney-client privilege. Now, despite the duty of an attorney to report, it is important to note that a lawyer's duty of confidentiality is not violated when disclosing or reporting information to appropriate authorities. This is a critical balance as it ensures that clients can trust their lawyers to keep their information confidential while still fulfilling their broader ethical and legal obligations to report misconduct. Take note that there's still a line that limits the obligations of confidentiality with regards to lawyers. It ends when it crosses the line of their ethical and legal obligations to report a misconduct. Okay. Section 12 also, in saying that any baseless report should be subject to criminal, civil, and administrative sanctions or actions, it gives a type of deterrence for those who would want to or would resort to this kind of behavior. This serves as a deterrent, against frivolous or malicious reporting, ensuring that lawyers only report information that they reasonably believe to be accurate and accurate and necessary to fulfill their ethical and legal duties. Can a lawyer directly impute a misconduct or impropriety or crime to another lawyer without basis? Obviously, a lawyer shall not directly or indirectly impute to or accuse another lawyer of misconduct, impropriety, or a crime in the absence of any factual or legal basis. Okay. This is based on Section 13. The duty of a lawyer regarding imputation of a misconduct, impropriety, or crime without basis. Bakit dinagdag? Malamang kasi ginagawa na paulit-ulit. It's the rationale first. On the first paragraph, it's to avoid unsubstantiated accusations. And second, it's to avoid frivolous complaints. How should a lawyer submit grievances against an officer of the court, tribunal, or government agency? A lawyer shall submit grievances against any officer or court or government agency only through appropriate remedy and before the proper authorities. It's based on Section 14. Under remedy for grievances and insinuation of improper motive. You want to remember the case of Henato versus Malyari. In this case, the one who challenged a Court of Appeals judge to a televised debate. Bakit? It says here that any grievances should be through the appropriate remedy and before proper authorities. In this case, the proper authorities would be the Supreme Court. What should a lawyer avoid in their dealings with officers and personnel of court, tribunals, and other government agencies? A lawyer shall observe propriety in all dealings with officers and personnel of any court, tribunal, whether personal or professional. Familiarity with such officers and personnel will give rise to an appearance of impropriety, influence, or favor, and it should be avoided. Section 15 of Canon 2, improper claim of influence or familiarity. We have discussed this as what? The duty to avoid any, what do you call it? Influence peddling in court. You can remember the case of Vantage Lighting versus Dino. Well, he represent when the defendant lawyer said that he could secure a TRO from the court for a fee. Sketchy. When should a lawyer report a life-threatening situation related to a proceeding? When a lawyer who has reasonable grounds to believe that a life-threatening situation is likely to develop in relation to any proceeding in any court, tribunal, or any other government agency shall immediately report the same to the proper authorities. In the proper authorities, well, law enforcement. Wait, this is based on Section 16 of Canon 2. What is the prohibition regarding solicitation and advertisement for lawyers? Okay. This is based on Section 17, non-solicitation and permissible advertisement. A lawyer shall not directly or indirectly solicit legal business or advertise legal services except with dignified, verifiable, and factual information. If you look at Section 17, on the first paragraph, it presents the general rule for prohibition for solicitation. Why? Because practice of law is a profession and not a business. If you look at second paragraph, it provides for the advertising guidelines for lawyers. It requires lawyers to provide dignified, verifiable, and factual information. Bakit? First is to provide the public with informed decision making when choosing legal representation. Now, providing the accurate and comprehensive information ensures that the clients understand the lawyer's qualifications and areas of expertise. The second reason would be to prevent any misleading advertisement or any deceptive branding practices. By mandating a verifiable and factual information, the rule aims to protect the clients from false and exaggerated claims that could mislead them into uninformed decisions. Now, the third paragraph refers to a prohibition of payment for publicity. It ensures fair competition in the legal profession. Now, bakit? Prohibiting payments for publicity ensures that legal professionals compete based on their merits and abilities rather than financial incentives. You can apply this case in the ruling in Can versus Imbilio. What is the prohibition against self-promotion for lawyers? A lawyer shall not make public appearances or statements for purposes of self-promotion, aggrandizement, or seeking public sympathy in relation to a terminated or legal matter. Look at this question. Harvey Specter is a prominent defense attorney known for his high-profile cases. Recently, he successfully defended the high-profile celebrity Mike Ross, who was charged with embezzlement. The case garnered significant media attention and public interest. After the case concluded, Harvey Specter held a press conference where he discussed the details of the trial, the strategies he used, and the reasons why he believed his client was innocent. He also expressed his satisfaction with the outcome and emphasized his role in securing Mike Ross's acquittal. During the press conference, he announced his intention to write a book about the case titled Defending the Unthinkable, the Mike Ross Trial. Harvey Specter violated the SIPRA by Did Harvey Specter violated the SIPRA by holding the press conference and announcing his book? The answer is yes, based on Section 18 of Canon 2, it's a prohibition for lawyers against self-promotion. Stated in Section 18, a lawyer shall not make public appearances and statements in relation to a terminated case or legal matter for the purpose of self-promotion, aggrandizement, or to seek public sympathy. What is the sub judice rule for lawyers? Sa rule, a lawyer shall not use any forum or medium to comment or publicize opinions about a pending proceeding that may cause prejudgment, sway public perception, tarnish the court's integrity, or impute improper motives. The sub judice rule is highlighted in section 19 of Canon 2. It lists down the possible outcomes for when a lawyer uses a forum to comment or publicize his opinion. What will happen? It may cause prejudgment. It may sway public perception as to impede, obstruct, or influence the decision of such court, tribunal, or the government agency, or which tends to tarnish the court's or tribunal's integrity. It will impute improper motives against any of its members and create widespread perception of guilt or innocence before a final decision. What is the requirement regarding disclosure of relationship or connection for lawyers? Now, a lawyer shall formally disclose on record any relationship or connection with the presiding officer, court personnel, lawyers, partners, associates, or clients that may require mandatory inhibition in a pending proceeding. Wait. Let's discuss that more. This is based on section 20, the disclosure of relationship or connection. Based on section 20, a lawyer shall disclose on record any relationship or connection with the presiding officer when, based on section 20, at the first available opportunity. The key time for disclosure is at the first available opportunity. This means that lawyers are required to disclose any relevant relationship or connection as soon as they become aware of them and before proceeding with any legal action or proceeding. This early disclosure is essential to ensure transparency and address any potential conflicts of interest or biases promptly. It allows the legal system to take appropriate measures to maintain fairness and impartiality in the ongoing legal proceedings. Now, what is the expectation regarding taking advantage of non-lawyers' lack of knowledge of the law? Ano? That's gift giving. Okay, skip that. Okay, this is based on section 22. A lawyer shall not take advantage of a non-lawyer's lack of education or knowledge of the law. Bakit? The primary purpose of a lawyer is to serve the public and not to browbeat any of those who has no knowledge of the law. What is the prohibition regarding instituting multiple cases and forum shopping for lawyers? Based on section 23, a lawyer shall not engage in forum shopping or institute multiple cases to gain leverage, harass a party, delay proceedings, or increase litigation costs. What is the prohibition against encroaching? Or interfering in any other lawyer's engagement. This is based on section 24. The duty not to encroach or interfere in another lawyer's engagement. Okay. It's a general rule, non-interference of professional engagement The general rule is non-interference in professional engagement of another lawyer. It is outlined that a lawyer should not directly or indirectly encroach upon or interfere in the professional engagement of another lawyer. This means that lawyers should refrain from attempting to communicate, negotiate, or deal with a person who is already represented by another lawyer, regardless of whether the legal matter is pending in court, in a court, tribunal, body, or agency. Now, what is the exception to the general rule? The exception is if the purpose is to grant relief against any unfaithful or neglectful counsel. Okay, the exception to the general rule allows a lawyer to provide proper advice and assistance to anyone seeking relief against the perceived unfaithful or neglectful counsel, provided it is based on the code. Okay? You can apply this case in the case of Binayan versus Adog. Okay, what is the duty of a solo practitioner? A lawyer in solo practice shall ensure that all matters requiring such lawyer's professional skill and judgment are properly and competently addressed. Here, the provision seeks to highlight competent handling of cases by a solo practitioner and to avoid any overloading and keep the expectation of clients with regards to timeliness and quality of legal services. What should be considered when choosing a law firm name? It should be no false, misleading, or assumed name. The continued use of the name of the deceased, incapacitated, or retired partner is permissible with appropriate communication indicating their status. How is a law firm defined? Any private office, partnership, or association exclusively comprised of lawyers engaged in the practice of law who hold themselves out as such in public. This is based on section 26. First paragraph defines a law firm. Second paragraph outlines the guidelines in choosing a firm name. What should a partner do when assuming public office? Partner should withdraw from the firm and have their name removed from the firm name unless allowed by the law to practice concurrently, based on section 27 of Canon 2. What conduct should lawyers in government service observe? You should observe the standard of conduct under the CIPRA, the Code of Conduct and Ethical Standards for Public Officials and Employees, and other related laws and issuances. This is based on section 28 under the Dignified Government Service Rule. What restrictions apply for lawyers who are formally in government service? This is important. They cannot engage in private practice pertaining to any matter before the office they were connected with within 1 year of separation. Justices, judges, clerks of court, city, provincial, and regional prosecutors are also prohibited from appearing before any court within their previous territorial jurisdiction during the same period. What restrictions apply to lawyers in government service regarding financial interests and gifts? As a rule, they cannot promote their own or another's private or financial interest in any transaction requiring the approval of their office. They should not solicit gifts or receive anything of value related to such interest. Undue favoritism towards those transacting with their office is also prohibited. This is based on Section 30, the prohibition on financial interest in transactions and gifts. What is the primary duty of a public prosecutor? The primary duty of a public prosecutor is to see that justice is done, with the obligation not to suppress facts, conceal, tamper, or destroy evidence, coach witnesses, or offer false testimony. What standards of behavior should lawyers in the academe adhere to? They should adhere to the standards required of members of the legal profession under the CIPRA, observing propriety, respectability, and decorum inside and outside of the classroom and in all media. This is based on Section 32, Rules on Lawyers in the Academe. Now, by adhering to the standards of behavior, lawyers can contribute to a positive and professional learning environment while upholding the ethical principles of the legal profession. What is required of a lawyer serving as dean, administrative officer, faculty member of an educational institution regarding adverse client's interest? Okay, conflict of interest regarding lawyers in the academe. The lawyers must disclose any adverse interests of a client to the institution. Kailangan i-disclose sa school. Okay, the Section 33 outlines two key principles. First is the disclosure of adverse interest to the institution. And second is the duty to disclose any adverse interest affecting students. What is the responsibility of a lawyer when it comes to paralegal services? The lawyer must direct or supervise a paralegal in their delegated duties. So, the first part of Section 34 of Canon 2 covers this question. The first paragraph of Section 34 defines a paralegal. Paralegal is one who performs tasks that require familiarity with legal concepts, employed or retained by a lawyer, law office, corporation, government agency, or any other entity for non-diagnostic and non-advisory work in relation to legal matters, delegated by such lawyer, law office, corporation, government agency, or other entity. And the second part of Section 34 regarding the duty of paralegals is, well, it refers to the duty of confidentiality. It extends to the services rendered by paralegals, and the paralegal is also bound to keep the privilege. Okay. What tasks are lawyers prohibited from delegating to non-lawyers? Lawyers cannot delegate tasks such as accepting cases, giving legal advice, acting independently, holding themselves out as lawyers, appearing in court without supervision, conducting negotiation without supervision, signing correspondence with legal opinions, or performing duties that only lawyers can undertake. Okay, This is based on Section 35 of Canon 2. Okay, hope this helps.